Hey, we're back with Justice for All. I'm George Yates with Katie Monroe and Sean Armbrust. And we are, my fascination, I think most people's fascination with this DNA exoneration is the folks that are on death row. Nick Yates is, we talked about in the last hour, and he's a famous example of it. And I did have him on my show, and he talked about trying to get that DNA, and finally, it was years, almost 15 years, he ended up having to be in federal court before a federal judge ordered all of that DNA evidence brought in to be tested, and he finally was exonerated, and he was on death row in Pennsylvania. Do you have any examples of people you've exonerated that were actually on death row and were going to get the death penalty?
The first case I ever worked on was I was a college student at Northwestern University in an investigative journalism class, and I worked on the case of a guy who had just come within 50 hours of execution and got to stay at the last minute because he was mentally retarded. And it turned out he was innocent, and the real perpetrator ended up confessing, and that case was part of what prompted the moratorium on executions in Illinois and ultimately ending the death penalty in Illinois. In Virginia, there's only been, I believe, one death row exoneration, and that's the case of Earl Washington out of Culpeper, which is, a pretty amazing case. I mean, he could have been killed several times over. And, luckily, at the end of the day, DNA was able to exonerate him, but it was a very long road, and he was almost killed for something he didn't do.
Now, Earl Washington, that's a famous case. Tell us about the facts of that case, and how was he wrongfully convicted?
So Earl Washington's case was a false confession case. So Mr. Washington was a mentally retarded African-American man who was picked up for a couple of robberies and was interrogated for a whole bunch of different crimes in the area, including the rape-murder, a rape-murder in Culpeper that had taken place, and that they hadn't yet solved. And it was a particularly bad false confession. For starters, he was mentally retarded, and we know that the mentally retarded are more likely to falsely confess than others. He was taken to the crime scene. He actually couldn't point out the crime scene. And he eventually guessed as he was being driven around. He got the race of the victim wrong. He got the method of killing her wrong. But at the end of the day, once you confess to something, people assume that you've done it. And he was convicted. And the struggle to get him exonerated, it was a little bit before my time. I think he was finally exonerated in 2001, which is right when I started law school. But it's a pretty well-known case, and I remember following it. There were exculpatory DNA results that were suppressed for quite a while. At the end of the day, those DNA results came to light, and Mr. Washington finally was exonerated, but not before someone who had committed a really horrible rape and murder remained free. And while, a poor mentally retarded guy who hadn't killed anybody was threatened with execution repeatedly, and came close to execution repeatedly.
Katie, are there any examples nationwide of anybody that's actually been executed and then DNA evidence later exonerated them?
There aren't any examples involving DNA evidence, but there is an arson case in Texas, the case of a man named Cameron Todd Willingham. There was an amazing New Yorker article written a number of years ago about the case, and there's not been to date any kind of formal ruling that he was innocent despite being executed, but pretty much every arson expert who's looked at the case has determined that it wasn't really an arson, and that he was, executed for committing an arson that killed his kids, but that no arson was ever committed.
There have also been, in Texas, there was the case of someone who died in prison before being exonerated by DNA evidence. And so the testing went forward even after his death, and he was demonstrated innocent, but he had passed away of illness while in prison. You also have a very famous case of Kirk Bloodsworth in Maryland, the first person to be exonerated by DNA evidence who spent time on death row. I think, we've had, I believe, 17 exonerations of people from death row, but there's no, the numbers are such when we know that the system makes mistakes. It's a human system. There's room for error at every single stage of the criminal justice system. We can't pretend that it doesn't make mistakes. And to the degree that, people are sent to death row as a result of criminal convictions, we have to assume, we have to know, frankly, that there are mistakes in those cases as well. So, often these cases don't go forward once somebody has been executed. The exoneration process would stop. But I don't think that we can believe that there aren't innocent people who get convicted or who get sentenced to death.
And that's particularly true when you start looking at the circumstances of exoneration in these cases, because, I think a lot of people look at these cases of exoneration and say, oh, that's great. It's proof that the system worked. I know the case I worked on in college, that's what everybody said. And, I was 21. I needed 2 alarms to wake up in the morning. And I was going, wait a minute, the fact that I helped do this really shouldn't be giving people any comfort. And then when you look at the circumstances, the case Katie was talking about, the police officer who happened to have the files in his garage, the case I worked on in college, the real perpetrator ended up confessing because there happened to be a news story on in his house while the investigator was there about the case. And it's a story that had been rerun and was being run in 5 media markets in the U.S. that day. Just happened to be on there. Cases where, we have one exoneration where there was a full DNA profile based on semen that was found on a 26-year-old pubic hair. These cases, there's a tremendous amount of serendipity involved. I tell all of my clients that they're incredibly unlucky to be in the situation they're in, and if they're exonerated, they're some of the luckiest people I know, because this kind of evidence doesn't just come around all the time.
What drives you? What drives you to do this? This is incredibly noble work. I'm sure you're not in it for the money. What drives you? What makes you do this? Katie, how did you get involved in this, and what drives you to do this kind of work?
Well, I actually think I was interested in this kind of thing very early on. When I went to law school. You're in law school. You kind of learn. You learn about how laws are supposed to work, how criminal justice officials are supposed to perform, how the Constitution is supposed to protect us. And then I actually got out of law school and did a judicial clerkship with a judge on the Virginia Court of Appeals, and the cases that came across my desk looked nothing like those standards and those protections I learned about in law school. I saw a lot of cases come across my desk where you could, speculate that the person might be guilty, but I didn't see the actual evidence there, right? And I got concerned, but then I actually ended up having a personal experience. Someone in my family was wrongly convicted, and I always like to say that my professional and personal lives collided at that point, and I've been in the business ever since. I think, and Sean, has a personal story as well, and she can tell you about that, having worked on a case, while she was in college. But I think most of us that do this, yeah, sure, it's noble. I mean, lots of people do lots of noble things. I don't think that's why we do it. We do it because, there's real professional and personal gratification in doing justice, right? I mean, these innocence organizations we're the checks and balances, the checks and balances, the check at the back end of the system, right? We're the people who identify when, to the degree that we can, when the system has made a mistake, and it's an extremely important service that helps not just innocent people in prison, but everyone. who is affected by wrongful conviction, and when we can do the investigation, whether it involves DNA testing or not, and identify that a mistake has been made, and then go through a very creative court process to free someone who's been wrongly convicted and to deliver justice, kind of not just to them but to the crime victim and everyone. I mean, it's a really exciting work. It's fraught with obstacles and fraught with disappointment, but it's very exciting work and it's very important work. So I think it doesn't require high pay to keep doing it. I will say though, and I think Sean should talk about this a little bit too, is all of these innocence organizations are they're nonprofit organizations, and resources are extremely limited, and the reality is we require on the support of generous people and foundations to keep the doors open and continue to do the work, so for people who care about justice and are concerned about mistaken convictions and the impact on the communities in Virginia, it's important to support the innocence organizations.
For me, I think I got hooked on this work in college, and I don't know exactly what it was that did it, but there was something that struck me. The case I worked on in college was a poor African American guy from the south side of Chicago, and nobody really cared about him. Nobody cared about the murder that he was convicted of. Nobody cared about him. And I just kept thinking about how differently I would have been treated if I had been in his shoes, and what level of representation I would have received, and how many chances I would have gotten. And it made me mad. And I think what keeps me motivated now. There's professionally, there's nothing more rewarding than walking your innocent client out of prison on his birthday into the arms of his mom. It doesn't really get better than that. And, kind of substantively, I've always liked mysteries, so I like the work substantively. And I also love that, every single one of these cases is a chance to make the system better. So there are a lot of kinds of public interest work you can do out there that are just working with clients or just policy work, and that work is amazing, and there are a lot of lawyers who do great stuff. For me, I kind of like that intersection between casework and policy, and I love the knowledge that every single case we work on is a chance to really make the system better.
And I'm sure you have colleagues that appreciate your work. And after do you have parties after you exonerate somebody? Do you all end up at the Captain George's and have a big? What happens after you walk somebody into the arms of his mom? Do you just then say, "Well, ho hum, off to the next one," or how do you revel in that kind of experience? Because you must want it to last a little while.
Yeah, we try to let our clients sort of spend time with their families when they get out and not crash the party too much. In our office, I've got a very tiny organization. There are 6 of us, most of us working moms. We do mimosas and pastries in the office to celebrate exonerations. That's kind of our in-office thing. It sort of depends on the situation, but we definitely try to celebrate, but we do try to let our clients celebrate with their families, because that's really the important thing.
And George, that feeling that innocence lawyers get, other lawyers and officials who work in these cases get those as well. The police investigator who comes to appreciate that a mistake was made in the case and can participate in an exoneration. It's thrilling for them as well. It's thrilling for prosecutors. We also, all of the innocence organizations work with civil law firms who provide resources and litigation support on these post-conviction cases, and they revel in these successes as well. And one of the things that I know, in my partnership work, I am constantly looking for places where we can, we have shared or common interests with prosecutors, police agencies, crime victims, judges, and others. And I get excited when a prosecutor has an opportunity, like Attorney General Cuccinelli or others who've been a part of an exoneration process, when they, it's exciting when they have an opportunity to share in that as well. I mean, I think, my hope is that more police officials and more prosecuting officials will understand that there is leadership, for them, and that the public really supports them when they can identify that a mistake happened and be part of correcting the record and providing ultimate justice.
I do a lot of practice down in Virginia Beach, and I just have the highest respect for the Commonwealth Attorney's Office in that city and the police department in that city. And I just every time I'm down there and I have any relationship with any of the prosecutors there, it's just a bunch of straight shooters, and I rarely see any kind of things that I sometimes, and then sometimes I read these horror stories, the Nick Yarris story being the one up in Pennsylvania. Do you? So I know that prosecutorial misconduct happens, of course, many times. I don't see it too often in my jurisdiction, but are you have any examples of where the prosecutors have just flat did the wrong thing and, as you say, hid the ball and really participated in some of these wrongful convictions, or is it mostly just innocent mistakes that have just been made, like just the wrong ID? What's your take on that?
So I actually have been shying away from calling it prosecutorial misconduct for a couple of different, for one main reason, which is that, we give defense lawyers a lot of leeway to screw up. We talk about how they're under-resourced, and for the most part, that's true. Defense lawyers are terribly under-resourced and terribly overburdened. And I think they're so under-resourced and underburdened that it kind of camouflages the fact that prosecutors are too. They're just a little bit less under-resourced and under-resourced and overburdened. So we see, kind of what's referred to as prosecutorial misconduct, what I'm going to call prosecutor error, I guess, in a lot of these cases. It is fairly common. But it's not necessarily the sort of vision of a diabolical prosecutor sitting there and sort of sneakily putting the evidence in a drawer so that no one ever sees it.
No, he thinks he's got the right guy, and he's just prosecuting it, right? I don't think you're going to find people prosecutors that aren't going to prosecute somebody they didn't really think did it.
Yeah, exactly. And so, for the most part, what I see in cases where evidence hasn't been turned over when it's supposed to be, it's, sometimes the police and the prosecutors don't do a great job of sharing information with each other.
Right.
So sometimes the police have information that they haven't given to the prosecutor, and because the police aren't lawyers and they're not getting great training on what they're supposed to turn over, they don't turn it over to the prosecutors, even though they should have. You have prosecutors who, their job is hard. They're supposed to do justice and be zealous advocates. And so you have to look at a case file as a prosecutor. And, for listeners who aren't criminal justice lawyers like we are, discovery in criminal cases isn't like in civil cases. What prosecutors are supposed to do is look at the file and turn over evidence that's favorable to the defense. But, of course, if you're a prosecutor and you've made the decision to prosecute somebody and you think they're guilty, you probably don't think you have any evidence that's favorable to the defense. So, your ability to kind of figure out what the defense wants and needs isn't that great. That's why open file discovery is a great idea, even though, it doesn't always solve the problem. But it's a good starting point when it's feasible.
I know when I was a prosecutor, it was a lot easier for me. I would just say, here's my file. Here it is. Look, and I know Hampton and Newport News in our area all have open file policies, and you can go take a look at their entire file. Virginia Beach and Norfolk and Chesapeake will just, you have to file your motions, and then they'll provide you what you're allowed to get under the rules. Hopefully you've got a good relationship with the prosecutor who can let you see their file, more informally and show you their witness statements and their summaries. But I do think that, in Florida, you can take depositions of witnesses prior to trial. You can't do that here in Virginia. But I really wish that we had a better discovery system here. I think in the long run, I know when I was a prosecutor, I'd say, wait a minute, I don't want to convict the wrong guy. here's my file. I don't want to be accused of a Brady violation, or not filing or not turning over information you're supposed to turn over. So I think that's a great step going forward. I think if we could open that up a little bit, have more open file policy. We got just a few more minutes in this segment here. If you've just joined us, we're here with two representatives of the Innocence Project, which is we're a great organization. It's the last barrier, isn't it? You guys are you're the saviors of the people. There's no other place for them to go. They've been convicted. They're in prison, and all their appeals have been exhausted, and now they're appealing to the Innocence Project. And it just must be very rewarding to get some of these people free who really have no other place to go. I'd like to, before we take our break, I'd like to talk about, in the next segment, I'd like to talk about, first of all, some ideas that you both have going forward that would streamline the system, make the system more fair, specifically eyewitness identification, which I know you're both involved in nationwide and here in Virginia. And the other is some examples of some of these people who have been exonerated and what they're doing with their lives now. But we're going to take a quick break here. This is Justice for All. I'm George Yates. We'll be back after these messages with the Innocence Project.
For the very best in down-home music, join us on Saturdays, 11 a.m. for Ramblin' Ralph's Bluegrass Special with the authority on bluegrass music, Ralph Coleman. Saturdays at 11 a.m. on AM 1650 WHKT. Ramblin' Ralph's Bluegrass Special.
Hello, this is Big Bear inviting you to visit myself and Grandma Bear at Little Bear's Consignment Boutique, where you'll find the best new and gently used children's brand name clothing and equipment. Clothing from newborn to teens. Dresses, suits, shoes, strollers, bassinets, toys, and anything else you need. Little Bear's is your stop. We even carry maternity clothes. Check us out on Facebook or stop in 200 North Battlefield Boulevard in the Harbor Watch Shops of Chesapeake near the locks. Little Bear's Consignment Boutique, where you're always greeted with a smile.
The place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their two locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at IndiaPalaceVB.com. On Facebook, look for India Palace Virginia Beach and India Palace Bar and Grill. Dine at the India Palace today.
The restaurant we've all been waiting for is here. Introducing Ipan Mano Kitchen. Critically acclaimed chef Silva Sennett and his culinary team specialize in new American Asian cuisine. The very best in Chinese, Japanese, Thai food with an American flair. Open daily for lunch and dinner, Ipan Mano Kitchen is located inside the Patrick Henry Mall in Newport News. Call 249-0033 and log on to ipanmanokitchen.com. Find them on Twitter at ipanmano.
The tradition of the Newport News Greek Festival continues with the fall edition October 23rd through 25th. All of your favorite Greek food, beverages, desserts will all be on display at 60 Trafford Road in Newport News inside the Hellenic Center on the grounds of Saints Constantine and Helen Greek Orthodox Church. October 23rd, 4 to 9 p.m. and October 24th and 25th from 11 a.m. to 10 p.m. For more, log on to newportnewsgreekfestival.org. See you at the Newport News Greek Festival Fall Edition October 23rd through 25th.
Opa!
All right, we're back with the last 30 minutes of Justice for All. I'm George Yates, and we're here with the Innocence Project. And first of all, I'm fascinated by some of these exonerated prisoners. The one, Thomas Hainsworth, we've talked about him. He apparently, I got a photograph here of him actually reuniting with his accuser, this woman named Janet Burke. And that is a fascinating. She was 18 years old when she was raped by the wrong guy. And how many years did Hainsworth do in prison before he was exonerated?
So he did 27 years, but hers was one of only 3 crimes for which he was convicted. So his sentence in her case was 10 years, and then he got longer sentences for some of the others. But yeah, I introduced the two of them at the beginning of the summer. I run the Mid-Atlantic Innocence Project, which is a nonprofit based in D.C., and we have an annual fundraising luncheon every year. And we were honoring a victim from North Carolina who misidentified her rapist and has been sort of barnstorming the country for 15 years talking about it.
Now, she wrote a book, right? Picking Cotton.
Yeah, fantastic book. It's something anybody can read.
And everyone should.
Yes, everybody should. And so I wanted to honor her, and she'd been kind of informally counseling this victim in the Hainsworth case, and I thought it would be great if this woman could present the award to Jennifer, but I realized that if I was going to do that, I had to introduce her to Thomas, because Thomas was going to be there. And so I set up a meeting between the two of them, and it was one of the most powerful things I've ever witnessed.
Because she wrongfully identified him and just and felt so bad, right? I mean, she ID'd the wrong guy. Go ahead.
She made a mistake. The two guys looked alike. She was 18. She'd been raped on her way into a church daycare center where she worked as a child care provider. And, Thomas looked a fair amount like the person who actually did rape her. And, one of the things that continually amazes me about my clients and about the other exonerees is how little bitterness they have.
Absolutely.
And kind of watching Thomas meet someone who, if you ask the average person on the street whether you'd be kind of mad at someone who mistakenly identified you, even if it wasn't their fault at all, as was the case here, I think most people would say yes, and Thomas wasn't at all.
I interviewed Nick Yates for 2 hours on this show, and you can go listen to our interview on my website at ghylaw.com or on my YouTube channel for this show. I was just blown away at how little bitterness he had and how much love of life he had, and it was really amazing. You would just think that somebody that's had so much of their life taken away from them would be angry about it. And I couldn't believe how kind and loving and forgiving he was for all of that. And apparently that's the way most of them are.
Well, as Sean mentioned earlier, they really are the lucky ones, right? It's really easy to be accused of something you didn't do. It's easy to be convicted of something you didn't do. All of that happens very fast. And can happen because, it's a system that's put in motion that you really can't stop. Proving that you've been wrongly convicted and that you're innocent and actually getting, the courthouse and the jailhouse doors to open up again is close to impossible. So I think that people who are exonerated understand that they've really, that they've beaten the odds and that they're lucky. But there's other voice in it, right? The original victim or the survivor of the rape or the family of the person who's been murdered. They've had much less of a voice in all of this, and that that healing, that component of of healing and having justice done in their cases is equally important. And Jennifer and Janet and others who have had the courage to talk about what happened to them and to identify with the exonerated individual in their case. They're like parallel paths, right? They've both been harmed, and they tend to understand each other. They understand that they've both been harmed. They've been harmed by the actual perpetrator and harmed by a system that made a mistake, and so they have shared experiences. And what Sean was able to do for Janet and Thomas in that instance, having them meet and be united and share in that parallel experience. Is really important.
Since your resources are limited and your requests are, I'm sure, in the thousands, how do you screen these cases out, and how do you ultimately make the decision as to which cases to work on?
You've just hit the nail on sort of the bulk of the work that goes on in my office, which again it's a tiny nonprofit. We're very meticulous about it. We have deadlines for when we have to respond to letters. We have deadlines for when we have to get people answers. But what we do, when we get a letter, we make sure it's from Virginia, Maryland, or the District of Columbia. We, if the person says that they have a lawyer, we can't correspond with that person. If the person kind of admits that they're guilty and wants help with something else, we can't handle that. But everyone else gets a very long questionnaire. We ask them to fill out the questionnaire, and we also ask for the appellate briefs in their case. And we have a screening director in the office who's wonderful, who kind of takes the first read at every single case. And she screens out kind of the people who obviously aren't claiming innocence. We get a lot of, people who, were going to rob the 7-Eleven with their friend and didn't know their friend was bringing a gun, which, may stink, but that's called felony murder, and, you're guilty of it. We get a lot of sort of he said, she said child sex cases where there's really not a lot you can do after the fact. But then, anything in which the person may be innocent and in which there may be a way to prove it, we request all of their legal documents. And we have a huge team of volunteer lawyers who help us wade through those cases. So we assign each case to 2 different people, and they write 2 different memos because, since we see so much tunnel vision in our own work, we try to avoid having our own, although it's hard. So we assign each case to 2 different screeners who write 2 different memos, and then our legal staff, has a conversation with each of those people based on the memos and makes a decision about whether we want to investigate a case further or close the case. And the cases we investigate all get assigned to a staff attorney, and the staff attorney our in-house investigator, and then, my organization's at George Washington University, so we have a team, tons of fantastic law students who work for us, work on developing evidence of either innocence or guilt. Whatever evidence we can develop that leads us to an answer. If we find out that someone's guilty, we stop investigating the case. If we, ultimately discover that there's nothing we can do, we also have to stop working on the case, and those are the really hard ones. And if we end up just, finding evidence of innocence, we sign on to represent the person, and we usually co-counsel with big law firms. Particularly in the non-DNA cases, the litigation is pretty intense and pretty big. It's more like a huge civil rights case than, a drug possession case. So we then litigate those cases.
So you'll partner with a large law firm, and then they can bring some of their resources to bear on the case. I would guess, right?
Yeah, it's part of how we have a paid staff of 5 and a budget of less than $400,000 per year, but we're getting my project and the Innocence project that Katie works at has been getting the most exonerations in the country for the past 2 years, and our ability to work with law firms and leverage our resources is part of why we can do that.
Right. Now, who does your testing when you have a DNA sample? Do you have your own lab that you use, or do you use the same state lab, or I guess when what process do you go through? Let's say you've screened out the guilty, you've screened out the ones you can't do anything for. You've now got some people you want to work on this case. You need to now start looking and trying to find the DNA evidence or wherever it might be. What do you do then? Do you how do you get it tested, and what's the process?
So it's different in each of our states. In Virginia, there's a statute that allows post-conviction DNA testing, and it requires you to use the state laboratory. And we have a great relationship with the state lab. Their department counsel is wonderful. We work well with the scientists over there. There have been a couple of occasions in a couple of cases where there's been a type of testing they don't do, and they've sent it to an outside laboratory. But for the most part, they do the testing when we're in Virginia because that's kind of what the statute requires. In Maryland and in D.C., we are allowed to use whatever lab we want, mostly because we're paying for the testing. In Virginia, we don't have to pay.
Good.
And, one of the things you have to think about in these cases is, the government usually wants to find the real perpetrator, and of course, it's a lot easier as the defense lawyer representing the innocent guy if you can find the real perpetrator. So you want to be able to upload the DNA into the FBI's DNA databank, and only certain labs are allowed to do that. So we've been using a lab in Northern Virginia a lot called Bodie Technologies, which does fantastic work. And so that's kind of the lab we primarily use. I know in different states they use different labs that are allowed to upload into CODIS, and there are a couple of scientists around the country who are known for just, it's kind of like having a brain surgeon. If you've got a really tiny DNA sample, you want someone with great hands who can extract tiny amounts of DNA. And in cases with really small amounts of DNA, sometimes Innocence projects around the country will use a couple of those scientists who are just really gifted at some of those harder cases.
Well, now, you've both been working for the Innocence Project now for some time. Who actually, at the beginning of the show, I mentioned that the Innocence Project, the first thing that comes to mind is Barry Scheck and Peter Neufeld. Are they still involved in the Innocence Project?
Yes, the Innocence Project in New York, which does works on DNA cases in all of the states. Barry and Scheck and Peter Neufeld are the founders of that organization, and they are still actively involved as co-directors. We have grown significantly in the past decade. We now have an executive director and a deputy executive director and a number of departments, but Barry and Peter are still actively involved in all aspects of the organization, and really, they are the fathers of this DNA movement. I mean, they are the ones who made it clear that DNA evidence can identify actual perpetrators, and by doing so, also identify innocent people in prison. And all of us in the community, and every single person who's been exonerated, and every law that's been passed, and all of the the criminal justice improvements that have happened as the result of these DNA exonerations. I mean, we owe all of that progress and those successes to the vision and leadership and really hard work of Barry and Peter.
Yeah, it's remarkable, and you remember him from the O.J. Simpson trial. And how he did all that cross-examination and direct examination and so on, and when you say the organization, the Innocence Project, started in 1992, and I'm thinking, well, the O.J. Simpson trial was I want to say 94, right? So they had already started the Innocence Project. It was in existence before that trial. Is that right?
Yeah, it was a lot of the Innocence Project started this way, as did a number of innocence organizations around the country. It started as a legal clinic at Cardozo Law School, and so a lot of innocence organizations were started that way, right, by a law professor who understood that law students and kind of utilizing the resources of a law school were a good way to go back and investigate and possibly litigate these cases. And so the Innocence Project wasn't was an extension of Cardozo Law School for a long time, and then only about 2040. So about 7 years ago became, or 8 years ago became a nonprofit organization separate from the law school. The Mid-Atlantic Innocence Project is a nonprofit organization, although it has relationships with law schools and utilizes the assistance of law students. But a lot of innocence organizations across the country are still housed at law schools, like the Innocence Project was back in the early 2000s and the late 1990s.
And so does Barry Scheck and Peter Neufeld, do they still try cases and defend cases, or do they spend most of their time involving themselves in this project?
They do it all. They do it all. They still teach. They're still advocates for policy reforms. They're still involved in really important civil rights cases, and they are actively involved in the Innocence Project and in the Innocence Network. And we're very proud and excited to have them. Still as deeply involved in the community as they are.
Right.
And I've been lucky enough to work with Barry and Peter since I was 22, and Peter was my co-counsel in the Hainsworth case. And, I can tell you that he was right there with Thomas's mom, the night before oral argument, and made sure to get to know Thomas's family on top of all of the other things he was doing. So they're great guys. They're brilliant lawyers, and it's rare to have those things and also be visionaries, and they've got all of it.
Well, so now on the Thomas Hainsworth case, when you say oral argument, these things are still not slam dunks, are they? I mean, once you start getting the evidence, then what? We talked about this procedure a little while ago. You've screened it. You've got now, let's say you've done some DNA testing. Do you ultimately then have to have a hearing, let's say, before the Supreme Court of Virginia, or where do you end up? You file this in the Court of Appeals. Where procedurally do you go if you start getting scientific evidence that starts leaning towards exoneration?
So the Hainsworth case, it was technically, even though there was DNA in one of his three cases, there wasn't DNA in a third. So that was where we were using the non-biological writ of actual innocence. And, if you ever want an example of how hard it is to win an exoneration, the Hainsworth case is a textbook example. That's a case where we had the Attorney General, two different Commonwealth attorneys on our side. It was litigated for 10 months. We were all litigating together, but it was litigated for 10 months. There were two oral arguments. Finally, I did an oral argument in front of 10 of the 11 judges in the Virginia Court of Appeals. And again, even though everyone agreed that he was innocent, the governor had actually let him out of prison. We only won by one vote in the Court of Appeals.
I don't get that. You mean you had the AG, you had Commonwealth's attorneys, and he'd already been released from prison, and the judges still barely ruled your way. Explain.
The standard for winning a non-biological writ of actual innocence in Virginia had been that no rational trier of fact could find proof of guilt beyond a reasonable doubt. That's a really high standard.
I'll say.
And so it's, virtually impossible to meet. And the only reason we even got there is because we did have the Attorney General on our side. The standard has since been changed, which is something that Attorney General Cuccinelli spearheaded. It now is that no rational trier of fact would have found proof of guilt beyond a reasonable doubt. So it's not a big change, and the Court of Appeals has ruled that it's actually a meaningless change. So it's an incredibly high standard.
Yeah, I mean, that's the same kind of standard that sometimes you have when you've tried a case in front of a jury and the judge is about to send to the jury, and you say, Your Honor, I'm asking, move to strike. The standard is no rational trier of fact. And, they say, and the judge will send these cases to the jury when he should have struck the evidence. But
it's the exact same standard, and that's part of why it's so hard to win, because the case law is terrible on that standard.
And so despite that Virginia has the statute, it does have, often an unworkable statute. And the only other jurisdiction outside of this mid-Atlantic region that has a non-DNA post-conviction factual innocence statute is Utah, and the standard there is clear and convincing, which is a high standard, but not nearly as difficult or frankly impossible of a statute standard is the statute in Virginia. And so while Virginia has shown leadership in that way, very few people, if any. I mean, Thomas was lucky. He was lucky, and still, despite having the Commonwealth on his side and advocating and understanding that he was innocent and advocating for his exoneration, still faced a huge uphill battle.
Well, we just have a few minutes left. If you've just joined us, we're with Katie Monroe and Sean Armbrust, and they're with the Innocence Project. Going forward, what's the future for you? I know you're working on policies to change the way eyewitness identification is done, and you've made great strides. Apparently, I know the city of Virginia Beach, from what I've been able to determine, is now implemented some procedures that you've recommended so that eyewitness identifications are more accurate. Because, if you've got somebody that has their purse snatched on a street and there's no DNA and they're going to identify somebody, that's the problem, isn't it? You do want to catch people. You do want to have crime be successfully prosecuted. So how do you strike that balance going forward so that the right perpetrator is convicted and the wrong perpetrator is set free?
I think most of the reforms we've recommended, or that we recommend, both with eyewitness identification, with false confessions, and with a lot of other things, aren't things that are going to let guilty people walk. They're things that are just good law enforcement and that are about making the system more accurate. And eyewitness identification is a perfect example of that. The reforms we recommend make eyewitness identification stronger, makes them harder to challenge in court. The law enforcement agencies that use those best practices all say that they're more confident in the cases they're bringing and that they're bringing better cases. So it really is, in a lot of ways, it's better for the system and its accuracy overall if these best practices are followed.
I interviewed Brandon Garrett, who's a UVA law professor. He's just written a book, Too Big to Jail, and I know that he's been on this committee to implement a model policy for all jurisdictions in Virginia to follow on eyewitness identification. What are the main points to make eyewitness identification more accurate?
There are 4 core reforms that we've been advocating over the past several years, that the Innocence Project and the Mid-Atlantic Innocence Project and other innocence projects have been advocating. The first one is what's known as blind administration of photo arrays and lineups. And that means that the person who's administering the array shouldn't know who the suspect is or shouldn't be able to see what choice the person is making. And that's not because we think police officers are telling people who to choose, but because we know that eyewitnesses are nervous and they're looking for feedback. And sometimes that feedback is inadvertent. Good job, that's our guy, you got it right. The sort of things a normal, sensitive person would say to a crime victim who just picked out the perpetrator after she was scared. Those have been shown to artificially inflate witnesses' confidence. And that's the number one thing that judges and juries look at when they're evaluating eyewitness identifications. So if you can sort of do something at the beginning to avoid inflating that confidence, you can make witnesses, you can sort of ensure that eyewitness identifications are more accurate and more accurately judged by juries. The second thing, and it also relates to confidence, is after a witness has picked someone out of a photo array or a lineup, get a statement in their own words right after the identification has been made about their confidence. The next thing is just to make sure that nobody stands out in the lineup. In the Marvin Anderson case, I think his photo was the only one either in black and white or in color. Oftentimes you see photo arrays or lineups where, someone doesn't have a criminal record, so their photo just looks really different from all of the other ones. And without even looking at the person's face, you can figure out who the suspect is because their photo is so different. And then the fourth reform is, I just lost it. There's confidence statements, blind administration, and instructions. So it's sorry about that. Giving the witnesses instructions that the real perpetrator may or may not be in the lineup, that they don't have to make a choice, and just to make sure, because if you're a witness and you're being brought into the police station to look at some photos, you assume it's because the police have a suspect and that you need to do your job and pick somebody. And so it's important to remind witnesses that that may not be the case, and that they may not be looking at the actual perpetrator and need to be very careful not to make a choice if they don't see the person who is the perpetrator.
Yeah, because if you got 6 photos there, then that's what 1 out of 6 chance they might pick the wrong guy, and if they got the suspect, he still might be the wrong guy.
And and it does happen in cases. I mean, it's the leading cause of mistaken conviction in DNA cases, and we see it. It's been kind of demonstrated over and over. In fact, when we do trainings or presentations, audience members can rarely, if ever, identify the right person, even when they're sitting in a room that that isn't a crime scene, right? Crime scenes involve stress and fear and trauma. that affect people's memory. And then, of course, we have these police practices that we know can actually encourage a mistake as opposed to discourage one. But one of the things that's been exciting to see is that in the jurisdictions, where these improvements have been implemented, police chiefs, police investigators really like them because it really does improve the quality of their investigation and lead to fewer defense challenges. And the other place we see that is in the video recording of interrogations. Again, that just helps protect police. It improves the quality of the interrogation evidence and takes the question, out of what happened and helps the state make its case. And Virginia does have a statute and a model policy, and what we're hoping is that the rest of the jurisdictions in Virginia will go ahead and implement those best practices, especially now that the National Academy of Sciences has spoken. Uniformity in procedures is important to the state of Virginia, right? I mean, that all police investigators are handling these eyewitnesses with the same procedures, right? So the cases aren't being handled differently from jurisdiction to jurisdiction. And we hope that those police chiefs who've already implemented these best practices can serve as leaders to the rest of the police community.
Right, and we have a really good set of police chiefs in our area. I know that, and we've in Virginia Beach I can't remember a case lately where we don't have videotapes of almost everything. The statements made by the defendants. You'll get the summaries. You'll get the entire disc sent to you by the prosecutors, and you'll have it all right there. And so there's no worry about. It might be a false confession, but it's all going to be on tape.
Yeah,
so you'll be able to determine it later on. Well, listen, we just our time is just about up here with Katie Monroe and Sean Armbrust, and I would like to thank you for coming on the show. I really do. Innocence Project is just one of those great organizations. Not everybody knows about it, Katie Monroe's the national director here, and Sean Armbrust is working in the Mid-Atlantic. And Mid-Atlantic is just Virginia, Maryland, and D.C., right, Sean?
Yeah, it's its own nonprofit called the Mid-Atlantic Innocence Project that focuses on Virginia, Maryland, and D.C.
If you haven't been able to listen to the entire show, you can listen to the entire show on www.ghylaw.com, and we'll upload this show, and we'll have it probably by Monday. And we've been talking about perhaps in a future show I might be able to get one of the exonerated people. I know that you were talking about picking cotton. That's a book written by this woman, Jennifer. I'm not sure of her last name, but is her name Cotton?
Jennifer Thompson and Ronald Cotton. Yeah. Ronald Cotton was the exonerated individual. Jennifer Thompson was the rape survivor in that case.
Right, and they've taken their little show on the road, right? They actually go out and do interviews and presentations together and so on. It's really fascinating. But we're going to have to wrap it up there, ladies. I really appreciate you spending the time with us today.
Thanks so much for having us, George.
Thank you, George. It was terrific.
All right, great. Thank you very much. And that's going to be the end of our show for today. This is George Yates. This is Justice for All. And like I said, this Innocence Project is one of those, I was telling people that we got some people from the Innocence Project today. And some people go, oh, great. And other people go, oh, well, what's the Innocence Project? So, but they do great work, and for those of you that are also interested in knowing more about this, there's the National Academy of Sciences has written a report on eyewitness identification, and this is a great story, really, about making sure that the right people are properly convicted, and the people that are innocent of a crime do not get convicted and perhaps executed or so for the serious crimes. But thank you very much for being with us today. I'm George Yates, and this is Justice for All. We'll see you next Saturday between 2 and 4 on 1650 AM. You have a great afternoon.